In this video, let us discuss an important topic called anti-defection law. The 52nd Amendment Act of 1985 provided for the disqualification of members of parliament and state legislatures on the ground of defection from one political party to another. It added a new schedule, that is 10th schedule of the constitution. This act is called anti-defection law. The 10th schedule of the constitution contains provisions with respect to the disqualification of members of parliament and state legislatures on the ground of defection, who all can be disqualified. Members of house belonging to any party becomes disqualified if he voluntarily gives up or he resigns from any political party, he stands disqualified. If he votes against his own party in the house and abstains during voting when called upon by the whip in the house, he stands disqualified. In the case of independent member, an independent member when joins any political party remains disqualified under 10th schedule of the constitution. In case of a nominated member, persons who are nominated in the house should join any political party within 6 months from the date which he enters upon his office. If he joins any political party after 6 months, he stands disqualified as a member of house. Here comes the interesting facts on the exception where 10th schedule does not apply. If a member goes out of party and merges with another party with a strength of 2/3 of its member, they are exempted. That is, a member along with 2/3 of same party merges with another party, the members are exempted. That means members does not get disqualified. 91st Amendment Act deleted that the fact that split with 1/3 members and joins another political party remains disqualified. Before 91st Amendment Act of 2003, the split with 1/3 member provision was exempted from anti-defection law. If a member after being elected as a presiding officer, that is speaker, or any other presiding officer of the house voluntarily gives up the membership of his party or rejoins the party after he ceases to hold the office, is exempted from the 10th schedule of the constitution. To make it more clear about split and merger, the 91st Amendment Act of 2003 deleted the provision of split by 1/3 of members. For example, if a party A has 30 members and the split faction with 10 members joining the another political party was exempted before 91st Amendment Act. After the act, it was deleted, and so no more members of split with 1/3 members are protected under 10th schedule of the constitution. Merger with 2/3 members. If a member of party with 2/3 members decides to merge with another party, for example, if a party B has 30 members, the faction group with 20 members merges with another party or exempted from disqualification under 10th schedule. Any decision on disqualification under 10th schedule is under deciding power of the speaker, who has the final say and his verdict is final. That does not mean it is above from judicial review. Court can review the speaker decision on disqualification whether the provision which was used to disqualify falls under the 10th schedule of the constitution. Let us discuss a case study of Maharashtra. Eknath Shinde vs Uddhav Thackeray Shiv Sena. The Eknath Shinde's faction of Shiv Sena broke up from Uddhav Thackeray Shiv Sena to join BJP, and Eknath Shinde becomes the new CM. Supreme Court verdict on this issue. Supreme Court observed that the governor called for a trust vote which led to the resignation of Uddhav Thackeray Shiv Sena was illegal. The court also said that it could not reinstate or follow the status quo because Mr. Thackeray as a chief minister, he resigned instead of facing a trust vote, but also said governor was justified in inviting Mr. Shinde to form the government because Mr. Thackeray was not ready to face a floor test.